Marks versus Stinson is the highest level election overturned by a court. It happened in 1994 when the Democrat Pennsylvania state senator was found guilty of shenanigans and his Republican challenger replaced him after a federal court heard the case. Hello and welcome to Sweet Home California. My name is Jennifer. Let me first say, for the benefit of our community censors, that this is purely a history lesson and any similarity to current events is purely coincidental and unintentional. I'm reading from the New York Times from an article dated February 19th, 1994. So, it starts off that saying Philadelphia's election system had collapsed under a massive scheme by Democrats to steal a state Senate election in November, a federal judge today took the rare step of invalidating the vote and ordered the seat filled by the Republican candidate. Again, this is from 1994. This has nothing to do with recent events. In making such a sweeping move, the judge, who was Clarence C. Newcomer of Federal District Court, did for the Republicans what the election had not, enabled them to regain control of the state Senate, which they had lost 2 years ago. Judge Newcomer ruled that the Democratic campaign of William Stinson had stolen the election from Bruce S. Marks in North Philadelphia's 2nd Senatorial District through an elaborate fraud in which hundreds of residents were encouraged to vote by absentee ballot even though they had no legal reason, like a physical disability or scheduled trip outside the city, to do so. In many instances, according to Republicans who testified during a 4-day civil trial last week, Democratic campaign workers forged absentee ballots. On many of the ballots, they used the names of people who were living in Puerto Rico or serving time in prison, and in one case, the voter had been dead for some time. Again, for the benefit of our YouTube censors, this has nothing to do with current events. This is from 1994. Continuing. Quote, substantial evidence was presented establishing massive absentee ballot fraud, deception, intimidation, harassment, and forgery, Judge Newcomer wrote in a decision made public today. Again, 1994. The district, which includes white, black, Hispanic neighborhoods, is overwhelmingly Democratic by registration. Nonetheless, campaign workers testified that widespread voter apathy had prompted them to promote, quote, a new way to vote to ensure victory, door-to-door votes. In addition to specific instances of wrongdoing, the state Republican Party, which filed the suit, contended that the door-to-door solicitation of votes by the Democrats was not permissible under the state election code, which says the Philadelphia County Board of Elections, quote, shall deliver or mail the ballots to a voter. The city, whose lawyers represented the Board of Elections, contended that the statute was open to broad interpretation, but throughout the hearing, Judge Newcomer made it clear he did not agree. Indeed, the 2 Democrats on the 3-member Board of Elections, on an elected body, testified that they were aware of the voter fraud, had intentionally failed to enforce the election law, and had later tried to conceal their activities by hurriedly certifying the Democratic candidate as the winner. Again, this is from 1994. Judge Newcomer ordered that Mr. Stinson, a 49-year-old former deputy mayor of Philadelphia, be removed from his state Senate office, and that Mr. Marks, a 36-year-old lawyer and former aide to Arlen Specter, be certified the winner within 72 hours. Quote, this is extraordinary relief, unquote, Judge Newcomer wrote. However, it is appropriate because extraordinary conduct by the Stinson campaign and the board tainted the entirety of the absentee ballots. The 2 parties agreed that Mr. Marks would not try to enforce the order and take his seat until the appeals court reviewed the appeal that Mr. Stinson said he planned to file on Tuesday. At stake is the result of a special election held last November to fill the seat made vacant by the death of a Democratic senator. The election was crucial because the party that won the seat would also win control of the 50-member state Senate. The judge decided to hear the case after state election officials and state courts rejected the Republicans' claims. The Republicans have an appeal pending before the state's highest court. They went to federal court on the grounds that there were violations of the Voting Rights Act and the Civil Rights Act. The Democrats, fearing the court would rule against them, suddenly adjourned the state Senate on Monday, 2 days ahead of schedule. But when the Senate reconvenes next month, barring any successful Democrat appeal, Republicans will control the Senate by outnumbering Democrats 26 to 24. Republican leaders minimized the effect of today's ruling, saying they were eager to work with Governor Casey, a Democrat, on reforming the state's health care and welfare systems. Ralph Teddy, the lawyer for Mr. Stinson, said in an interview, "We believe, as we have said from day one, that a federal court has absolutely no jurisdiction in a purely state law proceeding when there are appeals pending at the Pennsylvania Supreme Court." Mr. Teddy noted that 5 or 6 state judges had already reviewed Mr. Mark's case and that they had all dismissed it on procedural grounds without considering the merits. Again, this has no correlation to current events. This is from 1994. Continuing, the dispute has also captured the attention of the National Republican Party, which asserts that the accusations of voter fraud were particularly egregious. But some election experts noted today that there have been many larger cases of voter fraud in Chicago and Louisiana in the 1970s and Alabama in the 1980s. The case involving the Philadelphia seat, however, may be the largest example involving fraudulent absentee ballots. Again, this is from 1994. Mr. Marks won 564 more votes at voting booths than his Democrat opponent, but Mr. Stinson won the election by 461 votes after he obtained 80% of the 1,757 absentee ballots cast. Legal experts said that Judge Newcomer's decision was highly unusual because he threw out all of the 1,757 absentee ballots. The judge wrote in his ruling, "The will of the electorate is reflected in the votes cast on the voting machines." In justifying his decision to throw out all of the absentee ballots, he cited a similar situation in Alabama. In that case, the United States Court of Appeals for the 11th Circuit in Atlanta ruled in 1986 that there was no need to be, quote, "mathematically precise," unquote, when a candidate has engaged in, quote, "massive," unquote, violations of election law. The abuse of absentee ballot applications and the ballots themselves, which are typically written in English, has apparently become more widespread with the increasing number of Hispanic voters in the inner cities, according to Arlene Rubin, an executive director of Project LEAP, which stands for Legal Elections in All Precincts, a Chicago-based organization that monitors elections. Quote, "Vote fraud is moving out of the polling places and into people's living rooms," Ms. Rubin said. In the meantime, 2 criminal investigations are being conducted, one by the state attorney general Ernest Preet, Jr., and the other by the Justice Department. Let me get back to this. So, anyhow, if you would like to be brought up to date to see what's going on now with a completely unrelated case, remember what I just read was from 1994 and has nothing to do with current events today. But if you would like to find out what is going on today, check out the links in the description. Let me know your thoughts in the comments, and please remember to like and subscribe to help get this history lesson out to others, because as the saying goes, those that don't study history are bound to repeat it. Keep the faith, Patriots. God's timing is perfect. Be patient and keep praying. And I will catch you next time. God bless. Bye.